So good morning, everybody. It's lovely to see you all today. It's so exciting to have such a high turnout for this topic. I'm not sure if that's a good thing or a bad thing, but we'll all come away better for it at the end of it. I'd like to introduce you to Catherine and Alex from Gannon's. They're going to now take over the stage, introduce themselves and start talking, and then we'll move into some Q&A. So do have your questions ready. I suggest we do not interrupt them until they've finished, and then we'll do a Q&A session after that. So Catherine and Alex, a very warm welcome, and of course the rest of you a very warm welcome today. And over to you, team Gannon's.
Hello, thank you very much for joining the seminar. We hope you're going to find it really interesting. I'm Catherine Gannon and I am a founder. I set the practice up 20 years ago, so I've had all the trials and tribulations of founders, and I can confirm that they never go away, they continue, and in fact they seem to get worse and worse. I'm with my colleague Alex Kennedy, who actually has been brilliant and makes the founders' problems much less worse than they would otherwise be. He's got lots of experience, he specialises in disputes, and I tend to more look at the overall big picture. So without further ado, we'll move on to a summary of what we're going to discuss today.
Yes, so hi everyone, good morning. As Catherine sort of indicated, I'm a disputes associate. So perhaps before we start, a little bit of a health warning. It can't possibly be the case that all businesses end in bust-ups and fights, even if that's what my inbox suggests. But that being said, these sort of things do come up a lot. And we find that disputes between founder directors in particular can be really sticky and really difficult to resolve. So I hope everyone can see the slides just as I'm sharing. So why is it that these disputes are so difficult to resolve? Well, there are a few different factors at play. So whenever people come together in business, they do not plan to fall out. And this has a couple of practical consequences. Because they don't plan on falling out, they are very unlikely to have bespoke articles of association or a shareholders agreement or an employment contract, which specifies what is meant to happen if there is a fight or a disagreement or someone needs to leave the business for any reason. And that is why something we will probably be saying quite a lot this morning is, if you don't have these things in place, it might be wise to put them in place before a dispute ever arises. Another feature that makes these disputes within small companies very difficult to resolve is the fact that people are financially and emotionally interested in the business. Oftentimes these disputes arise in the context of a family business. I'm thinking of an example that I'm dealing with at the minute where it is essentially a dispute between parents and sons. The sons are in de facto control of the company, even though everyone involved is a director. And the sons are paying themselves far more than they would get in any other job, frankly. So even though we, acting for the parents, are now threatening to remove one son in particular as a director of the company, they will fight tooth and nail because they know, A, they will not get a better job elsewhere, and B, they know that there is some emotional heft in a fight between parents and children. And the other thing that I think makes disputes more likely to arise in small companies, perhaps, and certainly more difficult to resolve, is the fact that good faith disagreements can very quickly become entrenched. And what I mean by that is, if you think of the example of a company with two directors and equal shareholders, and they might have a disagreement about the direction of the business, taking on a particular investment, buying into a new venue. It could be anything. And it could be that each side is an equally possible avenue for the company. It might even be that they would both be good ideas. It just needs a decision to be made. But in a 50-50 company, a decision will not be made unless they agree. So these sort of disagreements can emerge quite quickly and very quickly become entrenched. And then really the solution is for the company to, well, we'll be talking about what the solutions are on this next slide. So when these disputes arise, it is almost always the case that the solution will be for one party to buy out the other party's shares or to find a buyer for the other party's shares. I suppose it's worth talking a little bit about why that is. I suppose theoretically someone could leave the business and remain a shareholder in the company, but in these small companies, having someone who holds a 50% shareholding or even a 30% shareholding or a 25% shareholding will likely cause all sorts of problems for the business going forwards. So really you want the departing founder, the departing shareholder director to sell their shares and to have no further involvement in the business. And really the only way that can be achieved is for the departing shareholder to agree to sell their shares. But that raises all sorts of new problems. So the most obvious of which is, how do you fund the purchase of the shares and who is actually going to buy the shares? So throughout this talk, we're going to be really focusing in on these three questions. Who is the seller? So we know that this is the departing shareholder, but depending on precisely who that person is, there may be various things to think about, and there may be certain things that we can actually use to our advantage. So for instance, if the departing shareholder is also a director or is also an employee of the company, we might be able to take advantage of certain tax reliefs, which might mean that we can actually give more money to that person and make the deal more attractive to them, making a settlement more likely. A very important consideration is, who will the buyer be? There is no marketplace for privately held shares or shares in small private companies. So usually you will not be selling the shares to an external third party. And even if you find a third party buyer who was willing to buy the shares, the remaining directors really need to approve of that new person coming into the business, and they may well not do. So usually the buyer of the shares will either be all or some portion of the remaining shareholders or the company itself. And both of these things have various considerations to think about. And the other big question is the literal bottom line. How is the sale going to be funded and at what price? We're not going to talk too much about the valuation of the shares during this talk, but I think it's worth noting that there isn't really an exact science to the valuation of shares, and there are various approaches to doing so, especially with these small companies and especially with growing companies. So oftentimes it is a fight in itself to agree on approach to the valuation or the identity of a valuer, for instance. So I just wanted to flag that. So the simplest approach, and by simple I mean the most straightforward approach, is for the departing shareholder to sell their shares to a person, be that an external third party if one can be found and if the company is happy for them to come in, or more likely an existing shareholder within the business, or perhaps an employee who is willing to come in as a shareholder, for instance. But in this case, the person who is buying the shares is responsible for finding the money to pay for the shares. The shares transferred to the buyer by way of it could be achieved through a stock transfer form. There doesn't need to be any particular formalities about how that is handled. And any profits on the sale will be automatically taxed as a capital gain. And we'll be talking quite a lot this morning about how to ensure that share buybacks are charged as a capital gain and the advantages that gives. But even with this very simple approach, there are problems. Some of these problems are things I've talked about a little bit already. the bottom line in particular, how is it to be funded? Very few people have the money to buy out another shareholder wholesale in a way that is likely to satisfy whatever underlying dispute is causing their exit in the first place. I think the phrase I like to use is the pockets might need to be, they'll need to have deep pockets to settle the underlying dispute. And the other point to think about is if some or more of the existing shareholders are buying the shares, their shareholding will increase. And it's not necessarily going to be the case that the shares are sold to in an equal portion to all the remaining shareholders. So it might be that you are effectively upsetting the balance of power in the company after this person has left. So that's something that can needs to be borne in mind as well. So that's the sort of simplest approach a shareholder selling to an individual. I'm now going to pass back to Catherine to talk about the more complicated approach, which is where the company buys back the shares.
Yeah, so company buying back the shares is very handy in that it's a way of using up distributable reserves that may otherwise have to come out of the company and be taxed as dividends. Of course, I appreciate in startups, many companies don't have any distributable reserves. But if you can dig deep and find some, and I'm going to explain what the term means, it can be definitely the best position. So with the company buying back the shares, it might not have all the money it needs to pay for the shares in one lump sum, but that's okay because there's a way to structure the purchase so that the company can pay in instalments. What the directors have to satisfy themselves of is that the company is going to have a sufficient distributable reserves to meet its debts as they fall due, and also to meet the deal that's put in place. There's no acid test on how you work out what that level of funds should be. It's a decision of the directors. And the risk is if they enter into a commitment to buy back shares that they then can't afford, the deal is undone and you're still left with a troublesome shareholder on your hands and a breach of contract claim. So there's a little bit of care and attention needed. But in reality, there's some creative accounting that often takes place because if you think you're going to have enough money and you've been relatively prudent as a director, that is often all that is required. And as with many of these steps, you need some paperwork to show what your thinking and deliberation was based on. Other than that, in practice, there's often very little risk to the directors. So the name of the game in selling shares or buying back shares is capital to avoid income tax or dividend tax. It's very unlikely that a buyback of shares could be treated as an income transaction, which gives rise at the highest rates of tax at 45% plus NIC. It can happen, and I won't go into the very complicated details, but it could happen. I'll just say it's quite rare. What's more common is the revenue say this isn't really a capital transaction. We're going to tax this as a dividend. And there are certain circumstances where if you fail their various tests, you will definitely be ending up paying tax. This is for the shareholder that's leaving at 30, up to 38% on the proceeds you receive as a result of the buyback. We're now going to take you through what you can do or what needs to happen in order to avoid dividends and in fact be treated as having received a capital payment. So there's two elements to look at. What requirements does the shareholder have to satisfy in order to receive capital treatment, and what requirements does the company have to satisfy in order to justify to the revenue this is not going to be taxed as a dividend, this is a capital payout. Insofar as the shareholders are concerned, they've got to be resident in the UK. If you're doing a share buyback, you have to have held the shares for at least 5 years. The shareholding must be substantially reduced, and I'm going to come back and explain what that means. And after the share buyback, you mustn't be connected with the company after the transaction. Substantially reduced is quite a tricky area in that, especially if you're doing buybacks in instalments, each time there's a buyback, you've got to have given up at least 70% of your holding. And also, not being connected means not only have you given up at least 70% of your shareholding, and if you're doing it in instalments, it's 70% of each shareholding you've got to give up. You've also, as soon as possible after the share buyback, you should resign as a director or an employee. As far as the company's concerned, the buyback's got to be for the benefit of the company's trade. And as with all tax legislation, they're sort of a bit waffly in practice as to what does that mean. Dissenting shareholders and arguing shareholders the revenue have conferred, buying them out will definitely be treated as for the benefit of the company's trade. However, there are other circumstances which aren't so clear-cut. You can go to the Inland Revenue and get a clearance, and that is something that we would recommend and do in grey areas, not where it's clear-cut, but in grey areas. And there are cases we've seen where the application to the revenue to have the transaction treated as capital has been rejected. One case was where there was a father and some kids, daughters, and it was said that when the daughters were going and their shares were being bought back, that wasn't for the benefit of the trade. I guess that's pretty obvious, but there are other instances. So it's great that if you've got peace of mind and get that revenue clearance, it definitely is something we'd encourage people to do. But you don't have to. It's very much a nice to have. So, connected with the great big, is this going to be treated as a capital transaction or not? You've got to consider business asset disposal relief, because if the departing shareholder can claim business asset disposal relief, it oils the cogs and makes the whole process often in life much sweeter. In order to claim BADR, business asset disposal relief, the departing shareholder has to have at least 5% of the share capital, and it has to be the ordinary share capital. Now, ordinary share capital means it has to carry at least 5% of the rights to voting, dividends, and capital. It's not uncommon, in order to reduce the tax burden on receiving shares, for employees and directors to be given shares with restricted rights. For example, they're often given shares that don't have any voting rights, because it reduces their tax bill on acquisition, because the shares are worth less than an equivalent share that does have voting rights. So you do need to have a look at the articles and shareholders agreements and see if normal ordinary shareholding rights have been curtailed in any way. And another point is the shareholder has to have been employed or a director for at least 2 years prior to the sale of the share or the share buyback. When we talk about sale, we're covering physical sales to an individual as well as the company buying back the shares. You don't have to have been paid much. You can be on a peppercorn salary as a director, but you do have to have been on the books. And it helps. You don't have to be filed at Companies House as a director, but the evidential burden is going to be reduced if you can point to this person and say they are a director at Companies House. And the whole advantage of qualifying for BADR is that the rate of CGT paid on the proceeds you receive from the buyback or the sale of your shares is 10% on the first million. So that used to be 10 million. It's now been slashed, but it's still attractive. And in startup founder situations, it's often enough to see the departing shareholder on his way to a new life and out of your hair, which is, of course, what you want to do. Final comment from me, and then I'll hand over to Alex again. All about this business of paying by instalments. Now, the revenue have recently shone a spotlight on this and decided they're not so keen on payments by instalments, but they are still possible. You can do it in two ways. You're going to have multiple transactions. So you're doing lots and lots of share buybacks every time the company's got enough money to pay for them. You're passing that material interest test and giving up at least 70% each time. But you're incurring quite a lot of fees, because every time you do a share buyback, there's resolutions, filings at Companies House, stamp duty. You're going to see the lawyers. And when you, as you will know, when you come to see me, it's never a cheap transaction. So multiple transactions tend to be avoided because of the cost. So what's more cost efficient, but the revenue are beginning to rumble and say they don't like this, is you split the legal and beneficial interest. So what you do on day one, when you've done the deal, you transfer the beneficial interest over all of the shares, but it's agreed whatever the instalments are, you only get the first instalment. And then as and when the company pays the balance of instalments, then the legal interest gets transferred, and that makes it a wholesale. So they're quite common, they're quite popular, but they're becoming increasingly challenged by the inland revenue. So, being good lawyers, we've come up with a new wheeze, which we think is absolutely watertight, and Alex is going to explain that.
Thanks, Catherine. So, whenever I gave my first example, I said the simplest solution is to find someone to sell the shares to, some third party to sell the shares to, or an existing shareholder to sell the shares to. So you're selling to someone other than the company itself. And that has all sorts of advantages. It avoids all the sometimes quite complicated rules about company buybacks. And it also all but guarantees that the share, that the proceeds of the sale will be taxed as a capital gain. So the solution that we have come up with is a way of finding a third party to sell the shares to. And what we do is we create a third party to sell the shares to. We create a new company that the exiting shareholder can sell their shares to. The quote unquote remaining shareholders will also transfer their shares to this new company, so that that company becomes the holding company of the company that we're seeking to exit someone from. And that way, the shares, the entire ownership of the holding company exists with just the remaining shareholders. The departing shareholder can go off and spend more time with their family, or pursue their own business interests, or do whatever it is they want to do. And they can be paid in whatever way we want to structure the deal. So they can be paid simply out of funds from the company that they're leaving. That can be facilitated with a loan to the holding company, which we'll talk about in a second. It could also be structured in some other way. It could be payments by installments, which we've already talked about. It could be that they receive loan notes in return for this. So it's a very flexible way of designing a deal. And whenever you're trying to resolve a dispute, that flexibility is really helpful. So it is quite a complicated structure. So we have created a diagram to explain it. Very technical diagram that it is too. So the picture over here on the left of the screen is the situation as it is whenever the dispute arises. So here we have a company with 3 shareholders. Let's assume that they have equal shareholdings, so they each hold 1/3 of the shares. Very technically, if these 3 shareholders are also directors, the 2 remaining shareholders, shareholders 1 and 2, would have the ability to remove the 3rd director, shareholder 3, via an ordinary resolution. So they could remove them as a director, but what they can't do is remove them as a shareholder. unless there is either some sort of leaver provision in the Articles of Association or a shareholders agreement, or if there is if they come to a commercial arrangement, which is what this is all about. So we're trying to move from this situation where we have the company and 3 shareholders to this situation where we have the company, which is a wholly owned subsidiary of the newly formed top company, which is owned by the remaining shareholders, and the 3rd shareholder is away, free to do whatever it is they want to do. So the way we achieve this is by first incorporating this top company. So we have to create a new company. The first shareholders and directors of this company will be some combination of the remaining shareholders. Usually we would give each of these 1 share. The remaining shareholders will then swap their shares in the company for new shares in the top company. And they will make that share swap in such a way that the shares are almost identical, or they're as close to being identical as possible. The reason we do that is so that that share swap is as close to being tax neutral as it can be. It can't be exactly tax neutral because the shareholding in this company is going to be different from the shareholding in the new company because we're removing a shareholder. So these two will have a higher percentage of shareholding in this company than they had in the original company. But we can make it almost entirely tax neutral, bar the stamp duty, which would need to be paid. An important point here is that while this swap is, this tax swap, or this share swap is happening, it's important to file a Section 431 election to ensure that none of this arrangement is going to be taxed as income, which for all the reasons we've already discussed is a bad idea, and is something that we really want to avoid. So we've gotten to the point that the shareholders 1 and 2 no longer hold any shares in the company, and all of their shares are in the new Topco. What we haven't achieved yet is exiting shareholder 3. So shareholder 3 already still holds shares in the company. What they do is they sell all of their shareholding to the new Topco. And because they are selling to a third party, they're not selling to the company itself, that any proceeds from that sale will automatically be a capital gain, which is obviously something we've been talking about, a desirable outcome. The other thing, or the other feature of this, is that because they're selling to the new Topco and not the company itself, we're not as worried about whether the new Topco has sufficient distributable reserves to finance a share buyback. So, for instance, these 2 shareholders could put money into the new Topco to finance the sale. This new Topco could take like bank lending. This new Topco could take lending from the company itself. Or the shareholder 3 might agree that some part of the consideration that they receive for their shares be structured in loan notes. So effectively, the new Topco will continue to owe them some money. And the advantage of using loan notes, if they are structured in a particular way, is that they can also be tax neutral, or at least extremely tax efficient as a way of paying for shares. So this next slide basically summarizes some of the points that we have spoken about. Yes, I think that covers all the points we've arranged. And this slide here just puts some figures on the example that we talked about. So in this particular case, which I think is a case study that we worked on, the departing shareholder received £200,000 in cash and £300,000 in loan notes. I think very technically, I think it's likely that the loan notes were probably in a different currency. Isn't that one of the rules?
They could have been.
They could have been.
They're in sterling, but you've got the right.
Sure.
Yeah. I
see. But this shows the flexibility of this arrangement. Similar to some of the other arrangements that we were talking about earlier, it is wise to ask for HMRC clearance before doing this arrangement, in particular to make sure that the share swap is going to be treated as a tax neutral share swap, a like-for-like share exchange.
You can get revenue clearance on that point.
Yeah.
Even though in share for share swap, as Alex said, you've got to have identical shareholders before and after. The revenue will allow an exception of one share, which is the share that's left over for the departing shareholder to use to sell back.
Yeah.
So you've got clearance knowing the revenue. Don't think this is avoidance.
Yeah. Excellent. So this, as we say, this is a solution we really like. It has a lot of flexibility and really gives us a lot of scope for negotiation, which is really helpful. So there are another couple of points that we want to pick up before we conclude and before we turn to questions. The most obvious of which I think is going to be giving comfort to the departing shareholder that they are going to get paid if they're not receiving all their consideration all at once. So Catherine spoke about payments and installments in the context of a company buyback, and I've spoken about payments and installments in the context of this sort of new Topco. And I think there's absolutely no reason why payments and installments shouldn't be made if you're selling to one of the remaining shareholders. I think the only reason not to do that is from the remaining shareholders' perspective. You don't want to keep the departing shareholder around any longer than is strictly necessary. So you might want to, for instance, ensure that they at the very least surrender their voting rights in the shares on day one, even if they don't actually get paid for all their shares on day one. But let's assume that this is a deal that has been long fought and hard negotiated, and the way it is going to work is that the departing shareholder is going to receive payments and installments over the next 18 months, 3 years, 5 years, whatever it is. It's very likely that they are going to want some comfort that they will actually receive that money, and two obvious ways that we like about or two obvious methods that we like to ensure that this happens is for the remaining shareholders to either give some personal security, so they can give a personal guarantee in the same way that directors of a company might give a personal guarantee to any lender, or we can draft in a charge. So we can ensure that the departing shareholder has a charge over the company so that if they are not paid, they will have a right to the shares. And obviously that's fairly attractive because it's almost like for like. They sold their shares, they're not being paid for their shares, and now they've got a right to more shares in the company. But I suppose there's no reason why it couldn't be a floating charge over assets of the company or whatever works. And some final thoughts from me. We've really focused on the process of buying the shares and purchasing the shares of the departing shareholder, but that doesn't address absolutely everything. The reason we focus so much on the purchase of the shares is that tends to be the thing that is stickiest and the thing that is most difficult to resolve. But especially if these discussions arise out of a dispute between founders and directors, it's likely you are going to want to settle all sorts of claims that one party may have against the other, or the company has against the directors, for instance. And this can be achieved in a couple of ways, usually by having either a side agreement which settles all of these claims, and I've referred to that here as a short form employment settlement agreement, Some of you might already be familiar with this, but if you, for instance, as an employee are made redundant or you are dismissed and the employer does not want to follow all of the procedures that they strictly need to follow under employment law, it's very likely that they will ask you to pay, they will ask you to enter into a settlement agreement in exchange for an enhanced redundancy package or a settlement amount. And that's really what this is. We can draft a very simple short form employment settlement agreement to sit alongside all of the other documents that we're putting together. Or we can draft a share purchase agreement, which is going to be needed anyway, which includes clauses within it that settle any disputes between the parties. And that tends to be what I do, I suppose, because I tend to start the drafting from the point of view of the dispute because of the nature of my work. But I've certainly worked on plenty of corporate transactions where they've had a short form settlement agreement that sits alongside everything else. And I've perhaps been parachuted in as an employment lawyer to provide the independent legal advice, which is a necessary component of a binding employment settlement agreement. That's really a talk for another day. And then the other point that I really wanted to pick up on before we turn to questions is that this whole saga, this dispute, however it is resolved, can be taken as an opportunity to effectively clean house and to put your documents in order to ensure that these sort of disputes don't arise again in the future. In particular, if you are following the Topco route that we talked through. Whenever you're incorporating a new company, that company is going to need articles of association. You're changing the shareholding anyway. That's a perfect opportunity to put in place a shareholders agreement, and it can help avoid these sort of problems arising in the future. So perhaps it's a little bit of cross-selling to our corporate team, but we would always advise that this is a good opportunity to clean house. Is there anything else that you wanted to say, Catherine?
No, other than the worst position a small startup can be in is to find there's 50-50 shareholding and directorship, and there's deadlock. Deadlocks are very difficult to resolve because no one can make a decision with 50%. So that needs to be avoided at all costs. And the only way out of deadlock is to threaten, hopefully, and not actually have to see through applications to court for just and equitable winding up. And I've seen lots of businesses just fall apart and come to an end because the parties couldn't resolve the deadlock. And then you run the risk that people walk off and take your valuable intellectual property with you. And it's very expensive to try and pursue that. And it goes out of date quickly. So whatever you do, if you're an investor or a startup, avoid the 50-50 deadlock scenario. That's all I would say.
Yeah, no, I completely concur. An awful lot of my work is dealing with exactly that. Companies in complete irreconcilable deadlock. No one can make a decision. They outvote each other. Yeah, it can be a real mess. All right, I think we can turn to some Q&A.
Yes. So we're now going to do a section where I'm going to ask you both some questions, and we're going to answer some of those. I might have a couple more as well, and then we'll go to Q&A after that, if that's okay. I know there's a few things coming on chat. Alex, I don't know whether you want to sort of look at them, but in the meantime, but my first question for you both is, my co-founder has started becoming very idiosyncratic. I think they may be taking hard drugs. What should I do?
Yeah, sure.
Hello, what should you do? Well, this is a situation we've actually seen more than once. Everything depends on starting point. What's the balance of shareholder power? And are they a director? If you, the person that's not taking the drugs, have got the majority of shares, then you've got a stronger position, because ultimately drug taking is gross misconduct. You can sack them. So you can sack them as an employee, starve them of money, resign them as a director at Companies House. But that then still leaves the question of the shares. What are you going to do with those? And you can't force, without a shareholders agreement, the sale of the shares. if you had a shareholders agreement, that he would be a bad leaver. Hey presto, Christmas has come early, you can grab the shares back. But without that, you're in greater difficulty. At least you can remove him from the business. Well, it's not going to be pleasant, but you can remove him from the business and remove him as a director. And then you'll have to come to a deal on the shares if you don't have a shareholders agreement. And indeed, you may go down the share buyback route. If the company's got a bit of money and it's likely to have a bit more money in the future, you may well, typical, do a share buyback. A lot depends on the value, what is that business worth, and the amount of security that the departing shareholder could demand will in turn depend on, how much is he getting for his shares. It's all a commercial risk-taking situation. What you do want to do is do it peacefully, because you don't want them destroying your business.
Do I have to tell the police?
No, well, I don't know. Don't listen to me on that, but I won't be going to the police. No, what you have to do is manage it properly. If you think, of course, let's not go straight to the kill. If you think it might be a one-off drug session and it can be okay, well, then you might take a different approach. It depends on the history. But they don't have to go to the police. But it is, I assume you've got an employment contract in place that would say drug taking is gross misconduct. But even if you haven't got an employment agreement in place, any tribunal is likely to regard drug taking on the premises as gross misconduct. It gets more tricky where they're taking their drugs outside of the office, but coming in bleary-eyed and not functioning properly. Then you've got capability issues, and again, you can sack for that. But it's not nice because you've never got any proof. So the answer to your question is you can get rid of him. It will have some nasty bits, but he doesn't have to be left in place to destroy your business. You can move on.
Thank you. My next question, my co-founder never lets me see the bank account, maybe because he's high on drugs, I don't know. But anyway, what should I do if I'm not getting all the management information I need, even though I'm a director of the company?
Okay, well, I'll take that one as well. But if you're a director of a company, you've got a right to see the bank account and any matters to do with finance, because ultimately you're responsible as a director, and there's legislation that makes directors personally liable as well these days. So it is very prudent and essential if you're a director to know what's in the bank account. If they won't reveal that information, ultimately you could go to court for an order for disclosure. You could try asking to see detailed management accounts, where that might have details of cash at bank. And you could ultimately, you've got to be careful before you notify the bank of trouble in companies, because they can get nervous and close ranks very quickly. But where you really want to be is having to have 2 signatures if you're concerned. And that should always be set up at the beginning. People don't realise this, but those that control the bank accounts often control the companies. And you need dual signatures on payments that are over certain limits.
Thank you very much. Okay, I'm not a founder of the company, but I'm a director. And I've discovered that one of the founders has encouraged someone to invest based on false information. What should I do?
So I think this sounds very much like the founder who made this statement has made a fraudulent or negligent misstatement and has encouraged someone to invest on the back of that. So I think, first of all, I think there's a real chance that they have personal liability for the statements that they've made. So the founder is in trouble. Let's talk about the company and your position as a director. I think as long as your statements you don't echo the statements of the founder, and you are, I assume if this is happening in the context of an investment round, for instance, there will be the prospectus and that sort of thing in place. And I think as long as that is all above board and correct and has all the usual proviso wording that this is you are sophisticated investors and this is the information about the company and don't refer to anything else. I think that probably does protect the company and protects your position as a director. Although I think it much depends on whether, as a question of fact, the statement, negligent or fraudulent as it may be, made by the founder actually is the thing that encouraged them to invest. But I think the legal jeopardy would be on the founder rather than on the company or on any of the other directors.
Yeah, I'd say so.
Do I have to do something about it though?
As in, do you have to correct the sort of mistake?
Off the records,
I think it probably,
you could do, but you wouldn't have any. We've got to act prudently as all times as a director.
Yes, and in the best interest of the company.
Yeah, and the best and shareholders.
Yes.
You've got 7 duties. One of them is shareholders. So I think I wouldn't do anything too formal. Off the record, I'd have a discreet chat and say, look, that's not the case. Let me just put the record straight on that.
Yeah, I think apart from anything else, otherwise you're just storing up animosity for later.
Yeah.
So I talk to the investor quietly.
You tell the proposed investor quietly. Yeah,
I think so.
And
what if
if
they've actually invested? What do I do?
Well, that's slightly more trouble. What do you do? Well, I still think acting prudently, the theoretical legal answer is you would have a discreet chat. The practical answer is you'd have to know how much have they invested and could you afford to compensate them and buy their shares back if they said, well, I want out. Because that's the problem. You're alerting them to a situation. You may desperately have needed the money to keep the business afloat. So in practice, your legal duties will be overcome by, crikey, what are we going to do? I think is the real answer.
It's a commercial answer.
It's a commercial answer, yeah.
Okay. What if my co-founder has got a loan into the company and is threatening to pull the loan and make the company collapse?
So they don't own any shares in the company. It's a director.
Yeah, they own shares. They're a director. We're 2 co-founders.
Are they a director?
They're a director. They've got a loan into the company, and they're threatening to pull it out and fold the company.
Okay. So, well, I think the starting point for all of these questions is, as a director, you owe a duty to the company to act in the best interest of the company for the benefit of its members, or if it's insolvent, for the benefit of its creditors. And that duty is a fiduciary duty, which means you have to put the interests of the company or its members or its creditors ahead of your own duty. So I think if they were to pull out their money and therefore precipitate the collapse of the company, there's probably a good argument that they have breached their duties as a director and that there is a claim that the company could bring or the members could bring via a derivative claim, or that the creditors could bring after insolvency.
You'd have to look to why would they do that, because why do they want to see the company be brought down? Are they doing it because they then want to be part of a pre-pack and buy the assets back for nothing from the administrator? So first job is, what's their motivation? Because really most directors should want to see that the company continue. Then again, can you negotiate some position? Have you been misapplying funds that could have been used to pay back the director? Could you promise to be a good boy in the future and make more regular payments? The company needs to show that it's been taking steps to avoid this situation happening, I would say. And also, the company should have had its loan agreements looked at, so you can't just pull out the loan without notice and without reason, without cause. Yeah. Normally, you have to give notice. Give notice if you want your loan money back. Then you might be able to do a deal where you turn it into a convertible loan. I mean, the guy might be saying this because because the company's doing quite well, and he thinks, "Oh, I don't want a loan. I'd rather have some shares, please, and I want to convert that loan into shares." So I think to answer your question, you need a little cup of tea and do some investigation to find out the motives, the personalities, and the state of the company and its growth potential, because all of that hinges on the next steps.
Thank you very much. Right. My co-founder has taken some serious expenses out of the business, but always challenges mine. What should I do? We're both directors.
So both of you are directors in this circumstance. Okay. So I imagine the thing that rankles you about this, if this is a purely hypothetical question, I imagine it's the hypocrisy apart from anything else. I suppose, again, my starting point is always the directors owe their duties to the members of the company to act in the best interest of the company. So they are sort of nickel and diming you on your own expenses while taking out their own expenses for who knows what purpose. That to me suggests that there is at least an argument that they are in breach of their duties as a director. So I think what I would probably be talking about or quietly threatening or loudly threatening is the possibility of what's called a derivative action. So technically speaking, when a director breaches their duties, they owe those duties to the company and the claim belongs to the company. A director is not going to agree to sue themselves. I'm going to assume, because it's the most interesting and most problematic example, that in this case you are 50-50 director shareholders. So they have breached their duty to the company and potentially by taking all these expenses, taking money and property out of the company without proper authorization. I think you could then say, I will bring a derivative action against you. And the way you do that is you draft particulars of claim as if they come from the company, and then you ask the court for permission to bring that claim in the name of the company. And in a situation like this, they would almost certainly say, yes, of course you can. And that, if you were successful in bringing that claim, he would then need to account to the company for the damages he has caused as a result of his breach. Of course, half that money will be his because he owns half the company, but you would also receive half of it. The other point that I think is really important here and is important for getting a deal at an early stage is that I think it's very unlikely that either of you would, well, certainly it's very unlikely that he would be able to use the funds of the company to finance the case. And what we tend to do in these sort of situations is write in our very first letter, you are personally liable for these and you cannot use the funds of the company to fund the case. And then we write to the lawyers when they instruct lawyers and say, this is a company dispute between shareholders. You cannot receive any company funds for paying your own fees, and any fees you do receive from the company will be held in constructive trust for the company. And that can be very helpful in concentrating minds and encouraging a settlement at an early stage. So I don't know whether there's anything else you want to say.
Yeah, I mean, when I was an employment lawyer, a proper lawyer doing work, and someone wants to sack a director, my first piece of advice would be, we'll go through his expenses claims. Because if you've been making expensive claims that aren't legitimate, that's the grounds for gross misconduct. So you can ruffle their feathers and begin to exert some power and influence just by challenging the existing expenses. Now, that can be quite difficult when it's directed to director. So that's where you might find it helpful to hire yourself a little interim HR person that can sit in the middle and help orchestrate those types of conversations. Because often there's bullying going on. If one of them thinks I can spend what I want and you can't, that seems to me like unequal. Burkhoff, we're talking about the House of Lords or something like that. He's just been found a king bully, hasn't he? So I personally would probably get an HR person to set up the conversations, and I definitely have the accountant review the expense claims and challenge them a bit first.
Thank you very much. That's really helpful. So I've got one last one.
And that's a common reason for sacking people, by the way, fraudulent expense claims.
Yeah.
Yeah.
Thank you. I've got one last one. So my co-founder wants to hand over their shares to their wife and perhaps their children for sort of some sort of tax arrangements they've got. Should I let them?
No, but well, yes, but you don't want a wife on the board because they may not be business minded. They might bring all sorts of, they might just hold up the normal process of business. I'm being very sexist, but that can happen. What you can do is change the shares. So the wife can have the shares, but it might take away voting rights to attend board meetings. And then if the wife dies, you might want to have the company's got the automatic right to have the first offer of buying the shares back. Yeah. So yes, you can let the wife have shares because she can have the dividends, but depending on who she is, you might not want her attending board meetings. And that's quite common to strip away that right and then have a right of first refusal from the estate to get the shares back again. Same with kids. You might not want sport brats on your board either.
Thank you very much indeed. Right, I'm now going to open the floor. I'm going to ask people to put their questions into chat because there's quite a lot of us and it's going to be too difficult if we shout out, and then I'm going to read the questions out to you, Catherine and Alex, and then if you could answer them, and then we'll stay in control of this session. So the first question is from Bill. Can you be a director as an officer but not as an employee? I think this is probably in relation to your structuring that you were talking about. Could the buyback be transacted in full with the instalments funded by personal debt from the recipients of the shares?
Well, the answer to the first question is yes, you can be a director and that is not an employee. Non-executive directors are exactly that. I think for the purpose of all the tax relief, etc., that we were talking about, you can be either an employee or an officer of the company, and either way will work. So for BADR, etc. And then could the buyback be transacted in full with instalments funded by a personal debt from the recipient, from the recipients of the shares, albeit? So this is so the purchaser is, takes out a loan and then pays in installments. Is that right? I think that could probably work.
The purchaser, an individual purchaser of shares can have loan finance.
Yeah.
But what the company can't do, if it's going down the share buyback route, is borrow money to buy the shares back.
Yeah.
Okay. Thank you. Next one is from Oliver, which is, there's a company with EIS money in the last 24 months, so the company can't buy back the shares. So have you got any ideas of how he could get a founder with ill health who's quitting, get their shares purchased in such a way that they can have some cash and everyone can move on?
EIS is difficult, isn't it?
For the EIS relief, you have to have had the shares for 3 years to get the EIS tax breaks. And if you sell the shares within 3 years, all those tax breaks have to get paid back to the government. Is there an exception if the reason for the sale is ill health? I don't know. I'd have to check it. I don't know the answer. There might be.
Were they to buy back those shares off that person, does that break the whole EIS scheme for everyone else too?
No, because EIS is given per individual shareholder. So you look at each individual shareholder. The company itself, if it's got qualifying trades, will continue to be a qualifying company. The other investors, if they qualify, will continue to be qualifying investors, because you look at matters on an investor per investor basis, not collectively.
Thank you. That's very helpful. Nigel's asking, from your experience, do you think the HMRC might claim your suggested solution is not acceptable?
I don't think so. So I think this is the Topco solution.
No. Well, so far there's been no mutterings that that's not acceptable. And the revenue would have difficulty challenging that because you're setting up a legitimate new company. You're legitimately funding that company. It's legitimately buying some shares back. There's no tax avoidance because the revenue accept, if you've had your shares for 2 years, you can get BADR. If you haven't had your shares for 2 years, you just sell as an ordinary shareholder, pay your tax at 20%. There's not much to challenge.
We're not. It isn't really a tax avoidance.
The buyback legislation we went through. You've got to have your shares for 5 years. Now that's different because that's all legislated. There's pages and stuff of conditions that have to be met. We've only given you the snippets, so they can challenge that much more easily because it's legislated. But the Topco idea is not legislated; it's commercial. Topcos get put in place all the time for all sorts of reasons.
Yeah.
Okay, thank you. Next,
mergers, spin-offs. We're always putting in place Topcos. So no, I think from what I know, based on today, it's safe.
Yeah, and indeed, might more likely to be safe than payments and instalments from other arrangements, which they've, as we say, they've sort of raised question marks about recently in sort of January and February.
But then if you've got your clearance from the revenue, you're safe.
Yeah.
So if they don't like the instalments, they'll tell you when you put your clearance application in. But the problem is lots of people think they can bypass that level of expense and just go straight to a buyback without the clearance because it's not essential, it's recommended. So they're the people that will be most vulnerable when they haven't got the revenue clearance.
thank you. George is asking a question. 2 founders, 50-50 shareholdings, both directors. One shareholder had to resign the directorship because of personal problems on the promise they would be reinstated later.
Oh, right.
The remaining shareholder subsequently refused to reinstate the director. It's now in dispute and litigation. How can the deadlock be broken in the company's best interest?
I see also that there is a reference to unfair prejudice here, which is helpful because that's exactly what I was going to talk about. So it sounds very much like this company might be a quasi partnership. A quasi partnership being a company where the founders have come together in the collective understanding that they would be involved in the management of the business going forward. So the example I always give is if I hold a share in Marks and Spencer, I do not have a right to go along to board meetings. My rights are limited to those of a shareholder to receive dividends and vote, and that's about it. But if I was a shareholder in a quasi partnership, a company that I helped found, being the sort of most obvious example of a quasi partnership, then I would be able to say that by virtue of my shareholding in the company, I have a right to be involved in the management of the company and all sorts of other rights perhaps as well. So I think it's likely that the argument here is going to be that we had a collective understanding that I would be involved in the management of the company in the future by virtue of the fact that I have this, shareholding, and in being denied the right to participate in the management of the company, that is impacting my rights as a shareholder. And therefore I can petition the court for relief, which is the unfair prejudice petition, which is sort of referred to in the question. Typically what you do whenever you bring an unfair prejudice petition is you ask the court for, what you are doing is you're asking the court for relief. And usually what you're asking for is an order that your shares be bought for fair value. Now, in this situation, that may or may not be attractive because this person doesn't want fair value for their shares. They don't want to sell their shares. They want to be involved in the management of the company. So they're likely to be asking for an order that they be reinstated to the board or that the company be managed in a particular way, or perhaps even that the other shareholders sells their shares to them. And these are all things that you can put in an unfair prejudice petition, but really the court has quite a wide discretion as to what it does. And usually they order that the petitioner receives fair value for their shares.
Okay,
The other thing that I think it's really important to say about unfair prejudice petitions is they are notoriously time-consuming and expensive forms of litigation because they are so fact-specific. They depend entirely on what was agreed between the parties on day one, and no one can remember, and there's a lot of disclosure, and litigation is always expensive and time consuming, but unfair prejudice petitions especially so. So the exact right thing to do is to mediate, which I see from the question is what's going to happen. So they should mediate, they should come to, and mediation has a really high success rate in solving these sort of issues, because the parties can talk very frankly to the mediator and say, well, what's really important to me is that I gain control over this piece of the company, for instance, or this piece of IP, or that I receive fair value for the shares. Whereas the other party might think that different things are important to them, and then a deal can be made in a way that's simply impossible through litigation. A, because the court has a lot of power, but it could, it can't insist on a commercial settlement, hiving up parts of the company, for instance. And B, what you can do in a mediation is you can be very frank about what you want and what is important to you and what is less important to you. Whereas in litigation and in pre-action correspondence, you can't do that because you can't show weakness. You have to be as robust on all points as possible, because it's all going to be put in front of a court. So that's why we always advise that mediation is a really good idea. So I'm pleased that they are doing that, but it's a hard road and it's a hard problem. That's why they're finding it difficult to resolve.
Thank you very much. So there's another question which we've had in, which is the Topco idea. What happens if how are the shares given or sold to Topco? What if the shares are worth 10 million, and what are the tax implications of putting in place this Topco? It's coming from Tony.
So the point here is that shares in, so the shares in the company are swapped for identical shares in the Topco. So I think really no matter what the value of the company,
it doesn't
matter.
The issue is you're going to have to pay stamp duty.
Yes.
Because it's not an exact swap of shares, because you've got this one person that's keeping his shares to sell out. So if it's worth 10 million, your stamp duty is going to be 0.5% of 10 million.
Or 0.5% of, is it 0.5% of 10 million of the whole
of the whole company? Yeah.
Yes, I suppose it is.
Yeah.
Because all the shares are being sold.
So that's the implication there. But other than that, there's no financial limit imposed under law or legislation. And so it's 0.5%, that's your cost.
Good. Okay. Right. I don't think there's much else that's come in. Has anyone else got any other questions they'd like to ask? I'm finding this fascinating, but do stick something in chat if you think you have anything else to ask.